Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about mental health and anti-Black racism. Cases that should have gone to the Supreme Court of Canada, but didn't. In the case of a murder trial, the accused argued that his mental health and anti-Black racism that had impacted him should be taken into consideration in informing his moral culpability for his actions. The court declined to consider them in the way the accused wanted. He was ultimately found guilty and given a very severe sentence. The case was applied for leave to the Supreme Court of Canada, which was denied. And the case raises very important issues. While the Supreme Court of Canada has given some guidance in cases about the way in which courts can take judicial notice of anti-Black racism or racism against any racialized group, while there are provisions in the criminal code that permit consideration of a person's Indigenous heritage, and while we have IRCA reports, or Impact of Race and Cultural Assessment reports, that can now be adduced at sentencing, there isn't a clear framework set out for how these things should be considered when they're advanced from the Supreme Court of Canada. And that goes doubly so for mental health. In fact, there are a lot of competing decisions from different courts of appeal across Canada dealing with the role in which mental health evidence plays in both a trial and in sentencing in determining somebody's moral culpability. Where a person has mental health issues that contributed to their commission of the offense but don't rise to the level of making them not criminally responsible by reason of mental disorder, there still needs to be a clear framework for judges to understand this, especially because our law is significantly behind where we are culturally in our society in understanding these issues and how they impact people. The courts are always lagging behind, and it would be helpful for the Supreme Court of Canada to give this type of framework and give this guidance to catch the courts up to where we are now, where we have a better understanding of the way in which these experiences and the trauma that comes as a result of them can contribute to mental health issues, and then those mental health issues coupled with the trauma can contribute to offending conduct. The Supreme Court of Canada could have put a clear framework in place to allow judges to better consider mental health evidence, particularly where it arises from trauma that a person experiences by virtue of being racialized, to allow them to better consider this in both the trial and sentencing process in a way that we don't see currently, where there are these competing issues of whether or not there needs to be clear sort of expert mental health evidence or whether simply raising somebody's mental health is enough. Unfortunately, the Supreme Court of Canada really, I think, failed to see the conflict that has been developing across the country in these appellate cases dealing with mental health and trauma affecting individuals. And it would be great to see the Supreme Court of Canada take the next opportunity they can get to consider these issues, to provide a clear framework, and to make it easier for people to advance this, rather than making it more difficult to raise these types of issues as potential mitigation or as potential issues on trial. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.